Thank you, Madam Chair. George, you coming up with me? Thank you very much.
You're welcome.
Thank you. Members, this is SB 428 having to do with the seals on the beach in La Jolla in my district. You'll note the bill is co-authored by Assembly Members Saldana and Fletcher. Mr. Fletcher represents the area. Saldana is immediately to the south, and it is in my Senate district. In 1931, the city of San Diego was granted a trust, the state tidelands in the La Jolla community for a public park and a children's pool. For decades, the children's pool served as a swimming area for children until the early 1990s when harbor seals began to haul up on the beach and use it as a rookery. About 200 seals are now on the beach regularly. The City of San Diego has requested the statutory list of allowable uses for the trust area be modified to include the words marine mammal park for the enjoyment and educational benefit of children. The site's been the subject of a series of government and court actions dating back to when I served on the City Council, starting in 1993, going up to 2000. Competing decisions have been reached in federal court and state court, and today the city is under state court order to restore the beach for human use, and before the state court could issue an order to remove the seals, a federal court issued a restraining order to prevent the removal. So the city's in an untenable position with the competing court decisions. The city has asked me to carry this bill and to let them have the option of allowing the seals to be on the beach. That language addition, adding marine mammal park for the enjoyment and educational benefit of children, would allow them that option. You may hear today from opposition that says the bill orders the city or directs the city to allow the seals to be there to the, in opposition to the children's use. The bill does not order the city to take any position. It allows them an additional option that they do not have now. And right now, the city has spent almost $1 million in responding to the various courts and going to trial. According to the draft environmental impact review, dredging the area would mean removing approximately 3,000 cubic feet of sand to restore the area to children's swimming conditions. Would not only be expensive, but it could result in environmental impacts that will have to be mitigated. So once again, the city is caught in a catch-22. After 7 years on the city council and 9 years up here, it's time to give the city a way out of this confusing and competing predicament that it finds itself in. And the bill has very strong support. The beach area where the seals are now is a very popular visitor area, although children and adults can no longer swim there because the seals have degraded the water quality. It's a very popular visitor spot, especially, ironically enough, with children. The bill supported by the Natural Resources Defense Council, the Humane Society of the U.S., Sierra Club, San Diego Coastkeeper, Wild Coast, La Jolla Friends of the Seals, and animal advocates. And the city attorney and his representative, George Schaefer, is here with me today. So I would ask for your aye vote.
Thank you. Can we have the witnesses in support?
Members of the committee, my name is George Schaefer. I'm a deputy city attorney with the city of San Diego. I'm here on behalf of the city attorney, Mr. Goldsmith, who used to be a member of this body, who strongly supports this legislation. I have included in the materials that have been distributed copies of a portion of the state court's ruling that happened May 27th, where the state court is ordering the city to develop a plan to disperse the seals, which we estimate is going to cost the city of San Diego $700,000 to implement. I also have included in the materials a copy of the federal court's order restraining the city from removing the seals until that lawsuit is concluded. As Senator Kehoe has pointed out, the city is trapped in the middle between the state court and the federal court. And the last item I included in materials was an editorial from the San Diego Union Tribune, where, as they note, it's an impossible situation for the city to be in, with one court ordering us to remove the seals and another ordering us not to. And the only beneficiary of this litigation has been the lawyers that have been bringing these lawsuits. We have spent over $1 million in legal fees because of this litigation. And the taxpayers of San Diego are hoping that this legislation will be passed and the use that is currently the de facto use can continue, with the City Council having the discretion what's the best use for the public.
Before we have our next speaker, since we have a quorum, I'm going to call the roll.
Skinner.
Here.
Gilmore. Here. Brownlee. Here. Chesbro. Here. De Leon. Here. Hill. Here. Huffman. Here. Knight. Here. Logue.
So, members, we are on item number 4, Senator Kehoe's bill, SB 428. We are hearing the witnesses in support. You may continue.
Thank you. My name is Jennifer Fearing. I'm here on behalf of the Humane Society of the United States and our approximately 1.2 million supporters here in California. Also today representing the San Diego Humane Organizations of the Animal Protection and Rescue League and the La Jolla Friends of Seals. And I'm here to thank Senator Kehoe for introducing this bill and urge the committee to pass this important legislation. SB 428 amends state statutes to give the city of San Diego the right to designate Casa Beach as a marine mammal park for the enjoyment and educational benefit of children in accordance with the federal codes protecting these marine mammals. Broadening the purposes of this coastal area to include use as a natural haul-out area for these seals advances the will of San Diego's citizens. And if this bill is enacted, the city of San Diego will be able to resolve a long-standing and expensive conflict, as we've heard, and to maintain the beach, if they so desire, as a valuable attraction that brings tourists to the La Jolla area and takes much-needed action to protect the seals and their habitat. So we're hoping today that you'll vote to enact this. Thank you.
Thank you. Are there any other witnesses in support? You can just give your name and your organization.
Hello, my name's Catherine Rhodes. I'm with La Playa Heritage, and I'm a civil engineer, and my main things is, yes, please on this, because of the dredging.
Thank you.
My name is Shannon Player. I'm from San Diego. I'm a docent for La Jolla Friends of Seals. I talk to the public overwhelmingly in support of the seals. People come from all over the world. We hope you will also be in support of the seals. Thank you.
Good afternoon. I'm Ben McHugh from Wild Coast, and we're an environmental organization out of Imperial Beach. And we think that this bill is really important in terms of protecting both the seals and people's ability to enjoy them. Thank you.
And your support?
Yes, ma'am. Moira Chop on behalf of Mayor Jerry Sanders and the City Council for the City of San Diego. In
Great.
support.
Any other witnesses in support? So we will now have the witnesses in opposition. You can sit right where that mic is.
My name is Tom Brady. I'm a citizen and a resident of San Diego, and I'm in opposition to 428. And there's a handout that you're getting that we've been unable to get up to you. And it relates to the why I believe that SB 428 won't work and will cost, if it is passed, will cost the state and the city a lot of extra money that neither the state nor the city has. The first part of the page is an agreement that the state entered into in 2005 and stipulated that they would be bound by the order of the court, the Superior Court, and they Bill Lockyer signed as the Attorney General through Nancy Sagasti, acting by and through the State Lands Commission. The bottom half of the page is the Judge William Pate's decision in Superior Court, and it reads, in order to protect the rights of the people of California to the full use and enjoyment of a unique asset the children's pool, the city as the trustee of the children's pool is hereby ordered to employ all reasonable means to restore the pool to its 1941 condition by removing the sand buildup and further to reduce the level of water contamination in the pool to levels certified by the County of San Diego as being safe for humans. This case was appealed to the Fourth Circuit Court of Appeals in San Diego, and the Fourth Circuit was unanimous in approving this decision, and the Judge Pate so ordered the stipulation to be placed into effect, and the city didn't file a brief. A friend of the courts at the appeal to the appeals court in San Diego, and it was appealed by the city to the state Supreme Court, and they decided not to hear it. So that's where we stand. And in my firm belief is that the judge, and this is on the last part of this handout, talks to his remedies. It's 2 pages of a 38-page decision of his, and it's very clear to him that the children's pool is the only public beach in California that's been taken over by the SEALs, and it goes back to the that it's not a natural condition. It is a man-made pool, and it goes back to the trust and the city's responsibility as trustee, which it hasn't fulfilled, and that's the reason for the increase in the number of SEALs. The city's been unable to clean the beach and dredge the sand, and we feel very strongly that the city should be allowed to go ahead and do that and not violate the trust agreement that was put into place in 1931 and affirmed again in 2005. And it's pretty clear from the state's willingness to be bound by the judgment entered into in this case. Either and this stipulation was made before the case was heard, so either the city would be able to use it as a marine mammal park or as a children's pool, and they would abide by whatever the court's decision was. And that decision has been upheld at the appeals court, and then a hearing was denied at the state Supreme Court. But I think that clearly if SB 428 is passed, that the city will find itself in more protracted litigation, and all that's really necessary, I believe, is for the city to disperse the seals and dredge the sand and probably save themselves an enormous amount of money. And the seals have been there for a number of years, and I think that there's no reason to believe that they can't continue to be there, but the sand, the children's pool has to be restored by court order, and the city's operating under a judgment from the court to that matter.
If you could wrap up your comments.
That's
complete.
essentially
Okay.
it. That I just think that 428 is not going to solve the problem. It's not a silver bullet, and that I think that there are agreements that are in place, particularly the stipulation. And I don't think your analyst has addressed this issue in his analysis of 428.
Let me see if there's any other witnesses in opposition. Any other speakers in opposition? Members, questions before? All right. Senator Kehoe, would you like to
Thank you,
close?
Madam Chair. Just to say, indeed, the bill doesn't preclude any future legislation or any future legal action by any parties in San Diego. It has been reviewed. This bill has been reviewed by State Lands Commission, Ledge Council, and the Attorney General of California. It is the authority granted to the city is absolutely. As such, it may award, revoke, or amend such grants in its sole discretion, the Attorney General wrote members. So I would not ask you to do something that wasn't allowable under California law. And again, give the city one more tool it may need to solve this very intractable and expensive problem that is now more than 10 years old. I ask for your aye vote.
Thank you. The chair's recommendation is do pass. Is there a motion?
Also move, but
Okay.
I do have a question,
Go ahead.
just to make sure I understand it. So this bill does not attempt at our level to resolve this conflict. It simply gives the city the authority
Correct.
to find a solution. Is that correct?
That is right. The bill doesn't direct or require anything in the city. It allows to be added to state statute, add marine mammal park for the enjoyment and educational benefit of children
Thank you.
to existing statute.
Just wanted to make sure I understood it really
I
clearly.
appreciate
Thank
the
you.
questions.
Assemblymember Hill, did you also have a question? Okay. Any other
Thank you.
questions? All right, then we will, we've got a motion and a second. Do pass. Let's have the roll.
Skinner?
Aye.
Skinner, aye. Gilmore? Aye. Gilmore, aye. Brownlee? Aye. Brownlee, aye. Chesbro?
Aye.
Chesbro, aye. De Leon? Aye. De Leon, aye. Hill? Aye. Hill, aye. Huffman? Knight? Aye. Knight, aye. Logue? Aye. Logue, aye.
Thank you.
Pass. Bill's out. Passes.
Thank you very much.
Thank you. All right, we will now go to file item.
Coming up.
Wait, how do I even have it, Pat? How do I even have a pathway bill on
right here.
Yeah, but I don't have one. Which one is it? Is it SB 833?
833.
Oh, okay. File item 8 for SB 833, Senator Pavley.
You're right, it threw me off.
Yeah, it's like, wait a minute. Thank you. You may
Thank you.
open.
Good afternoon. Before I start, because I haven't been in this room for about 6 years or so, like 4 or 6 years, for historical purposes, the gentleman in the picture, fourth from the left behind Assemblymember Hill, is my great-grandfather, and I didn't know that till I was elected to the, not that I didn't know he was my great-grandfather, but I didn't know his picture was in this building. And didn't know he was ever in California until then. The curator confirmed that.
Right.
He's with Hiram Johnson there, who was the governor, and they were talking about referendums and recalls and initiatives.
Wow.
Well, I'd like to start, as Assemblymember Skinner said, I'd be glad to take the amendment suggested by your staff as outlined on page 3, comments 2 and 4, the analysis. This is a omnibus bill from the Senate Natural Resources and Water Committee. It was non-controversial. It's a technical cleanup language to existing legislation. It has been approved by all members of the Senate Natural Resources and Water Committee on a bipartisan basis, received unanimous support, not only in committee but on the floor. Specifically, this bill, at the request of the Association of County Recorders, makes a technical change in mining laws in the way that owners are identified on reclamation plans, and makes a technical change in the form that is used when Native American remains are discovered. The bill also adopts the terminology of the Franchise Tax Board for landowners to substantiate the tax treatment of appraisals, and it makes 2 minor changes in public trust provisions in San Francisco. This bill would also make minor changes at the request of the California Department of Forestry and Fire Protection to clarify the language for defensible space for fire prevention and protection. And lastly, the Coastal Commission asked for corrections to mistaken cross-references regarding amendments to certified port master plans. I ask for your aye vote.
Steve Wallach, on behalf of the City and County of San Francisco, we urge your support and here to answer any questions you may have.
Great. Are there any other witnesses in support? The motion is before us. Any witnesses in opposition? All right, so the recommendation is do pass as amended. It's the motion's on the floor. And it goes to local government. Any questions? Seeing none, we will call the roll.
Skinner?
Aye.
Skinner, aye. Gilmore? Aye. Gilmore, aye. Brownlee? Brownlee, aye. Chesbro?
Aye.
Chesbro, aye. De Leon? Aye. De Leon, aye. Hill? Aye. Hill, aye. Huffman? Knight? Aye. Knight, aye. Logue?
Bill's out, and it will go to local government. Thank you so much. All right, so our next item is file item number 3, SB 309, Senator, no, she's not. Okay, all right, so we'll do the consent calendar. Do we have a motion? Thank you. Do we have, thank you. Second by Assemblymember Gilmore, motion by Assemblymember Brownlee. We will call the roll. Oh, and the bill on the consent calendar is file item 2, SB 230, Senator Cogdill.
Skinner.
Aye.
Skinner, aye. Gilmore. Gilmore, aye. Brownlee. Brownlee, aye. Chesbro.
Aye.
Chesbro, aye. De Leon. De Leon, aye. Hill. Hill, aye. Huffman. Knight. Knight, aye. And Mr. Logue.
Consent calendar's out. So we're missing some senators. All right. While the sergeant calls the missing authors, and as soon as they arrive, we will deal with their bills. Okay.
How about Maldonado? Maldonado?
Oh, okay. Okay, and members, I'm sure it's in your binder, but just a reminder, file item number 6, SB 624, Senator Romero, was pulled. And we will hear it at our next committee. Put them in my binder, and that way, because sometimes I have the binder with me when I'm on the floor, and then sometimes bored there. Has he tried to get Kip up here? Okay. Except if he shows up and there's nobody else here, I don't know how to do it. Tell him to call his office. Might as well. Kip, I know the protocol is to let Steinberg's bill go last, but since there's no other members there.
Yeah, well, there's Senator Maldonado.
Okay. All right.
I told him the hearing would be short.
Okay. So, Senator Maldonado, thank you very much. We will go to file item number 5, SB 571.
Thank
May
you.
open.
Thank you, Madam Chairwoman and members. SB 571 authorizes a state oil and gas supervisor to deny approval of new or expanded geothermal well operations for operators who have not complied with formal order of the supervisor. Currently, the supervisor does not have this authority, and we'd like to give him this authority. The reason this bill was amended was we had some technical amendments from the Department of Conservation. So I'd ask for an aye vote.
Thank you. Do we have any other witnesses in support? Do we have any witnesses in opposition? And the motion should be with the technical amendments that the author has submitted.
That's correct.
Okay, so the recommendation is do pass. We will, as amended, correct. As I just stated that. Anyway, we will call the roll.
Thank you.
Skinner.
Aye.
Skinner, aye. Gilmore.
Aye.
Gilmore, aye. Brownlee. Brownlee, aye. Chesbro. Chesbro, aye. De Leon. De Leon, aye. Hill. Hill, aye. Huffman. Knight. Knight, aye. Logue.
Bill's out. Thank you, Senator Maldonado. Now we will go to file item number 3, Senator Duchesne, SB 309.
She's number 1.
Oh, sorry, number 1 and 3. So we'll start with SB 167. Apologies.
Thank you very much, Madam Chair and members. This bill would require the Integrated Waste Management Board to include in their 5-year plan as a border activity, the development of projects in the California-Mexico border region. We have an ongoing issue that's been around for some time of the awkwardness, and it's unique to the fact that we are in a border community. Tires purchased in the United States, for which the fee is paid to dispose of tires in California, often end up on cars or in other ways before they are actually scrapped, sent to Mexico. And so the bill has been, the tire moves to Mexico and then flows back in a river, and like this, the Tijuana River Valley, or the New River, or the Alamo River, because they aren't properly disposed of. The board has been trying to deal with border activities, put it in their plan. We want to encourage that, but we need the ability to make sure the board can, in fact, pay to implement those plans by doing preventative activities in Mexico to make this work appropriately. Ask for your aye vote.
We have a motion by Assemblymember De Leon with a second by Assemblymember Brownlee. The witnesses in support, would you like to add?
Yes, my name is Ben McHugh, and I'm representing Wild Coast for an environmental nonprofit in South San Diego County in Imperial Beach, and we're basically on the front lines of this issue. We're dealing with cross-border pollution on a daily basis, and so it's a great honor to be able to come up here and talk to you a little bit about it. This is a trail, a multi-use trail in the Tijuana River Valley in San Diego County that, with a little more than half an inch of rain this past winter, became filled up with tires and trash from Tijuana. And actually, just about 2 weeks ago, we had a community cleanup where over 300 volunteers came down, and in a little over 3 hours, we picked up 700 tires, or 7 tons of tires. And many of these tires actually were exported in the first place from California. And so we really see Senate Bill 167 as a way to break this tire cycle. The problem is many of these tires are used on south of the border for a short period of time on cars because there's a market for them. And yet there isn't a market for the recycled tire products like we have here in California. And so this is simply a matter of the Waste Board being enabled to work with our neighbors in Mexico to create a market for waste tire products and to ensure that we break this tire cycle, and so we're not continuously dealing with these waste tires as they come across the border. They're not only an environmental threat, they're also a public health threat, dealing with mosquito-borne illness and encephalitis. And they also greatly impact our recreational abilities in the South Bay. So I really would like you to support this bill. Thank you.
Thank you.
Madam
Okay.
Chair and members, I'm Michael Hawkins, representing the Rubber Manufacturers Association of America. We're here in support today. We represent the 8 major tire manufacturers that manufacture in this country. I will just reiterate what the Senator has said. The basic problem is that at the other side of the border, they don't have the programs that they need to have. We're not allowed to spend any of the money. It would be very cost efficient to create programs where we assist Mexico in establishing these programs for markets for them, recycling of them, and so we're partnering with the Senator in supporting this bill. We feel that actually it will be cost effective in the long run to do this. So anyone that thinks that this is money going to Mexico, we're having to spend the money to clean up already. So we're in strong support of the bill and would ask for your aye vote.
Thank you. Do we have other witnesses in support?
Barry Nelson with the Natural Resources Defense Council, simply urging your aye vote for this measure. We are listed as a supporter of an important measure, we think, to deal with waste tires along the border region. Thank you.
Thank you. Other witnesses?
Thank you, members of the committee. My name is Dustin Lauerman. I'm here with the Planning and Conservation League, and we urge your support. Thank you.
Thank you. Any remaining witnesses in support? We'll hear from witnesses in opposition. Are there any?
We're not aware of any.
No witnesses in opposition.
Comment,
Do we
Madam
have
Chair?
any? Yes, please. Assemblymember Chesbro.
Well, I just don't want to miss the opportunity to point out that the tire recycling program has been tremendously successful in reducing both the illegal disposal of tires around the state and also reducing the legacy piles, the massive piles that from time to time have caught on fire and created toxic horrors, But this has been a real conundrum about how to deal with the tendency for these tires. One of the places they go is across the border, and then they come back and in a very serious way. So I think this is an important additional step to the existing very successful program that's being carried out by the board.
Go ahead, Assemblymember Brownlee.
Just a quick question. Looking at this picture, so your bill goes into effect and all the tires get picked up. What happens to the rest of the sort of debris there? And is this really, this would be the sort of the first time that there's been a law that says you can go across the border for
a little bit. All along the border, all border states are dealing with these issues, and all the Mexican border states are trying to put in new laws. Some of them are imitating some of our things about fees. I mean, there's a lot of work going on, and this is now the Border 2012, which is a federal task force, has looked at this issue. We have managed finally to clean up. We had massive tire piles of the kind that caught on fire in the Central Valley years ago down in Mexicali for years until recently. Border 2012 did grants. They finally got cleaned up. They actually reused the tires for energy in a cement plant. So, we've got cleanup going on, and the effort is that in our region, it's a cross-border issue, and you got to give us the flexibility. The most cost-effective solutions are often things that can be done better on the other side of the border. So
if that was on our side of the river, if that was on our side of the border, and integrated waste management
would clean it up.
That is
our side of the border. That's the problem.
But
that is our side of the border.
But they would clean up everything, or just just the tire?
The tire itself would. Well, no, this is a river valley, so
right.
There's multiple issues. The Tijuana River has multiple issues. It is a south to north flowing river. All of our rivers in our area flow north to south to north, both in Mexicali and from Tijuana. So, we have multiple issues there, and it is the estuary. The point is that the watershed for the entire, both San Diego and Tijuana side of the border, the entire watershed dumps into the Tijuana estuary. The Tijuana River Valley is the estuary for the entire Tijuana watershed. Well, that watershed comes from mountains 60 miles away on both sides of the border and brings everything it can with it. So, we have multiple issues, but we've been doing a lot of work in that area, multi-agency. It's federal, it's state, it's local. Everybody's involved trying to do a variety of things. We have sewage cleanup, we have sewage plants, we have other issues that come up. But the tires, you always worry about the big tires that Senator Chesborough was talking about. It's after the experience we had in the Central Valley in the 90s.
Fire was in a place called Wesley.
Yeah. Oh, there you go. In the 90s, we all know what can happen. And, if it's here, then the tire gets recycled at the point of, you could explain how the program works better than I do, but
I think it's a great bill. It seems like once you go and clean up something, you should go clean up everything.
Well, they do, but it's all volunteer cleanups. And you try to take what you can get, and we have funds for this purpose. We have a joint binational, federally approved programs for dealing with this particular issue. And yes, we deal with multiple issues on an ongoing basis through other mechanisms.
Thank you.
Assemblymember Gilmore.
The state kind of can take the lead in.
Assemblymember Gilmore also has a question. Go ahead.
Thank you. Thank you, Senator. I'm just curious, how are the funds going to be administered?
Through the Waste Board. The Waste Board has the funds now. It's the funds that they collect. And our point is only, we're collecting that fee on the tire when it's sold in California. And what we're missing is the opportunity, usually we recycle it here, but in our case, the tires leave, and then the recycling opportunity that would happen when it's disposed of isn't there because we aren't doing the cross-border training that's necessary.
Okay. Would this possibly be done through grants through Mexican states or?
Yeah, it's more likely that we would. Yeah, the odds. I don't have their actual plan before me. I know the Waste Board has been doing a plan. We've done things through universities in the past. We've done things with cities. It could be done through the city of San Diego or our own administering, but certainly has to be in partnership with the Mexican state, with the state or local authorities in Baja California. A lot of this is training programs and education programs and things that we already do here. What we use that tire money for here, we do the training, we do the education, we set up the systems that allow the tires not to be disposed of in canyons and rivers. And the idea is mostly to help out with that kind of technical assistance to those agencies who are interested in doing it but don't always have the resources.
Madam Chair?
Thank you.
Yes, Assemblymember Chesbro.
I can't answer the two questions specifically in the case of the cross-border problem, but in around the state,
Yeah, the way it works.
there's both piles that are almost entirely tires, to your question, Ms. Brownlee, which are generally just funded out of the tire cleanup funding. But when there's mixed waste, which frequently, you have illegal disposal and it's all kinds of things, there are other funds for illegal disposal cleanup, and generally the funds are combined. There's an estimate made of how much of the waste is tires and how much of it's other stuff, and so there's a supplementation. Whether that's going to be the case here or not to bring the different funding together, I don't know. It really depends on how the board approaches it. And with regards to the cleanups, in many cases, in fact, in most cases, the cleanups of both illegal tire disposal and general waste, mixed waste, is done by contractors. So the state, basically, there's a list of qualified contractors who the board contracts with to do these cleanups.
Yeah, this would be not the cleanup. The point of the spending on in the cross-border partnership is the training, the technical advisor, the ability to help create the same kind of markets we have created for playgrounds, for roads, so that the tires get reused, and that we use our resources to assist Baja in coming up with those programs and developing those programs for implementation. They have an interest in it, but they don't quite have the system. And we know a lot of the tires are actually California tires to begin with. So we've collected the fee. Even if they collect the fee, these tires wouldn't have that. And so unless we do it as a kind of a joint program, we sort of don't get the best bang for our buck.
Yes, Assemblymember De Leon.
Just a quick thing. I've lived on both sides, in Tijuana and San Diego, so I just want to commend you, Senator, for doing the right thing. I know how the Tijuana River Valley gets when the rains come in, and it's not a pretty sight. And that's, some folks can argue that's the least of the problems, the tires itself down there. So I just want to commend you for the bill.
Okay. So we have a motion do pass, Assemblymember De Leon, with a second by Brownlee. The chair's recommendation is do pass. I also think this is an excellent bill. I think we all know that the problem with waste and pollution is it knows no borders.
Doesn't know where, exactly. So we will has no idea where that line is. Thank you.
Skinner?
Aye.
Skinner, aye. Gilmore?
Aye.
Gilmore, aye. Brownlee? Brownlee, aye. Chesbro? Chesbro, aye. De Leon? De Leon, aye. Hill? Hill, aye. Huffman? Knight? No. Knight, no. Logue?
Bill's out. Thank you so much. So we'll start with your next bill. You can.
Thank you very much, Madam Chair and members. SB 309 simply encourages our California Conservation Corps to target that one portion of our population that, as we have been doing budget issues over the last few years, we find is the one that we most need to target in order to make sure that we relieve ourselves of the burden of so many people in prison. We have found over the last several years that over 70% of our inmates are former foster children. If we do not take care of our foster children at the front end, then we end up paying them for them for life at the back end. And we think the Conservation Corps is a very strong program that, by targeting emancipated foster youth, could really help them get that footing that they need when they're just left at 18 without additional resources, the ability to have some stability, some funding, some basis for getting jobs, some basis for ensuring they graduate from high school or get their GED, and get that footing to be independent and hopefully non-incarcerated adults.
Great. So we have a motion from Assemblymember Hill. Do we have a second? And the motion is do pass. Second from Assemblymember Brownlee. Do we have witnesses in support?
Good afternoon. Crystal Mullenkamp on behalf of the California Association of Local Conservation Corps in support. This bill recognizes that foster youth are some of our state's most vulnerable young people, and that conservation corps are especially well suited to provide these youth with the green job training that will really propel them forward. We urge your aye vote.
Any other witnesses in support? Any witnesses in opposition? I also think this is an excellent bill. I was an employee of the Federal Conservation Corps when there was a Federal Conservation Corps, and worked with that program for 2 years, and really saw firsthand the job training skills, the job readiness, and the basic, well, there were education components too, which at the same time the youth were being paid so that they were being able to meet basic needs and really gain in a skill set and a maturity. So I think these things are essential for helping to minimize the population later in prisons and other. So,
Thank you. And I think as part of our economic stimulus, we have to recognize there was a reason that Conservation Corps was created in the 30s, and it did help a lot of people become and at the same time provide important public works projects. And I think we need to think about how to keep this one going. It's kind of been half-starved for the last several years, and it's important that we find it's now getting federal stimulus dollars to do important work for fire clearance and such, and we need to keep these programs going and hopefully expand them as resources allow in the future. Ask for your aye vote.
excellent. So we have the motion do pass, and we'll do the roll call.
Skinner.
Aye.
Skinner, aye. Gilmore.
Aye.
Gilmore, aye. Brownlee. Brownlee, aye. Chesbro. Chesbro, aye. De Leon. De Leon, aye. Hill. Hill, aye. Huffman. Knight. Knight, no. Logue.
Bill passes.
Thank you very much.
Thank you so much. We will now go to the final item, item number 7, Senate Bill 722. We've gotten a request from the President Pro Tem to have his staff person, Kip Lipper, present the Bill 722. Mr. Lipper, would you like to open?
Madam Chairman, thank
This
you.
is our chance to beat up Senator Lipper.
We will allow you to continue, and we'll ask our committee members to please not interrupt the presenter.
I apologize.
Thank you, Madam Chairman and members. SB 722 is a measure that passed this committee before. It's Senator Steinberg's bill to create a truth in advertising law related to the sale of carbon emission credits. Carbon offsets or carbon credits are credits that people buy and sell that say that a unit of carbon dioxide has been reduced from being emitted into the atmosphere, thereby reducing global warming and greenhouse gases. This bill simply says if a person wants to sell you a certificate saying they have reduced carbon pollution, they must actually demonstrate that they have reduced that pollution, or an authoritative body such as the Air Resources Board has determined that that was the case. According to the Wall Street Journal, the market for sale and offset of carbon credits is at over $100 million a year currently, and it's growing. Millions of individuals, as well as corporations from General Electric to Chevron Oil, have bought carbon offsets to reduce their greenhouse pollution and carbon footprints. There is currently no law in the books, either in California or elsewhere, to ensure that consumers get what they pay for, that is, that carbon pollution was verifiably enforced. This law builds on the current truth in advertising laws in California to ensure that parties do get what they have purchased. There currently are no guidelines, regulations, or oversight at the federal level by the Federal Trade Commission. However, this bill provides that if the federal government does act at some future time, then the provisions of this bill would be set aside. The bill is supported by a number of environmental groups who are here, and Senator Steinberg would ask for your aye vote. Madam Chair, I would just mention one other thing. Comment 3 of your committee analysis suggests that there might be other ways to have expert agencies such as the Air Resources Board certify these credits, and I think Senator Steinberg would be open to any amendments suggested. I do think he's concerned, especially with all the concern about the Air Resources Board expenses associated with implementation of AB 32, that those amendments not create any additional fiscal pressures. So with that, Senator Steinberg would ask for an aye vote.
Thank you. And before we hear from the witnesses in support, let me just state that the amendment that you're indicating his willingness to support is an amendment that would enable CARB to, if they choose to, either adopt their own standards or recognize one or more existing standard that is in the marketplace as the standard. Thus, they would not have to go to the, if they were to opt to go for one of the existing standards, then they would not have to do the work required of establishing their own.
That's correct.
So that's the amendment. Witnesses in support.
Good afternoon, Madam Chair and members. Delaney Hunter on behalf of Pacificor. We're a multi-state public utility. We operate in 6 western states. We support the intent of the bill. We do believe that customers need to have truth in the advertising that goes on. We currently have a Blue Sky program that allows our customers to support additional renewable projects. And because we technically advertise the carbon offsets or reductions associated with that, we get trapped in the bill. Because we are in 6 states and the program does operate seamlessly across those 6 states, a California-only program doesn't really work for us. So we're encouraged by the amendments, though frankly I think we'd like to see a little more concrete acceptance of mechanisms outside of California. We currently use data through the Western Energy Coordinating Council and then calculations through the US EPA. So we'd actually like to see if the amendment could go a little further in recognizing national or international protocols.
Well, the amendment would enable CARB to do so if CARB chose to.
Okay. I think our concern is if they don't choose to, what happens to programs that are operating multi-state is our concern.
Other witnesses in support?
Yes, Madam Chair and members, Bonnie Holmes-Jan with the American Lung Association of California. And we also are speaking on behalf of the California Thoracic Society to express support for SB 722. And we are concerned about the potential for fraud and false advertising in the emissions offset market. And we believe that offsets must represent real, verified emission reductions that will contribute to reduced global warming. And we think there is an increased level of statutory guidance that's needed. And this bill would put that guidance in statute and would provide the stronger state oversight that's needed over this aspect of AB 32 implementation. And we just think it's a very important effort toward making sure we're getting the greatest air quality and public health benefits out of AB 32. Thanks. Urgent vote.
Other witnesses in support?
Thank you, Madam Chair. Barry Nelson with the Natural Resources Defense Council. We also urge your aye vote. We believe that it's very important that that both the public and purchasers have confidence that they know where they're getting when they purchase carbon offsets, and we think this is an extremely important bill. Thank you.
Any other witnesses in support? So Assemblymember Chesbro has moved the bill with amendments. Assemblymember Hill is the second. Do we have any witnesses in opposition?
Good afternoon, Madam Chairman. My name is Bob Lucas. I'm representing the California Council for Environmental and Economic Balance. And I'd like to say at the outset that we fully support truth in advertising, and we also fully support high-quality voluntary offsets. However, the devil is in the detail in this bill, and in the way the bill is drafted, it is going to be extremely difficult to qualify any voluntary offset. The amendment that you're discussing right now is going to be particularly important, and I'll explain why. There's 3 channels to qualify an offset under this bill. One is being in compliance with an Air Resources Board methodology. There are none. The other is being in compliance with protocols adopted by CCAR. There are a couple, but there aren't very many. The third channel is to meet 4 criteria that are established by this bill, and you have to meet all 4 of them. One of them restricts the offsets to California, something that's verifiable by a California government agency. So offsets, pursuant to that, offsets outside of California need not apply. Another blurs the line between voluntary offsets and compliance offsets. Another one has to deal with contributing to violations of national or state ambient air quality standards, which is extremely broad and very vague. Now, you take that particular channel, which is the only one that's realistically open right now without this amendment you're talking about, and then you apply it through the enforcement mechanism of a citizen lawsuit where there's no requirement for standing. That was taken out in the last amendment. So now anybody that wants to can sue. And then you couple that with a bounty hunter provision where they can also get their lawsuits or their attorney fees paid. Now you're encouraging people to sue, which means that if someone puts a voluntary offset on the market and advertises it, and there's any ambiguity at all in what they say about that offset, anyone could come and bring lawsuit here. So that amendment that you talked about is extremely important, and if it's all right with you, I'd like to work with your staff and the member staff to see if we could write it in such a way that it might help cure some of these problems. And we do agree with the earlier witness that the bill ought to be more explicit about recognizing offsets from entities outside of California, because right now it's restricted. Thank you.
The intention of the amendment is for CARB to have the flexibility to recognize not only existing standards but also existing protocols, with the understanding that that currently CCAR does not have a protocol for every type of carbon reduction that an offset might represent. So given that CCAR does not presently, if CARB feels that there are existing protocols or existing standards, and there are many right now that are emerging internationally, including the VCS, Voluntary Carbon Standard, the Gold Standard, and a couple of others, that if CARB feels that they are protect the consumers adequately, then they could choose to designate those. But let's have our witnesses in opposition continue.
Thank you, Madam Chair. Kim Stone with the Civil Justice Association of California. We must respectfully oppose Senate Bill 722. We feel that it will invite unjustified litigation in its efforts to reduce greenhouse gas offsets. CJAC supports fair advertisements. California Business and Professions Code sections 17200 and 17500 already allow lawsuits for fraudulent advertising. If I'm sold a greenhouse gas credit that turns out to be fraudulent and have lost money or suffered injury, in fact, I can sue under those code provisions right now. But this bill allows a lawsuit from any person, whether that person bought the carbon offset or not, and even if the carbon offset fulfilled its intended purpose to reduce that amount of carbon from the air. I would direct your attention to page 4 of the bill, lines 15 through 19, which delineate the requirements that the seller of the greenhouse gas must post. And they've got to post public health impacts associated with the creation and maintenance of the credit or emission reduction, including impacts on species, habitat, ecosystems, land use, biodiversity, air quality, water supply and quality, access to food, and productions of food. That means that whether I bought the credit or not, I could sue the seller of the credit because the information that they provided was allegedly insufficient, even if the offset did exactly what it was supposed to do. The lawsuit trap deepens with the ability for a party to get attorney's fees and costs. And as my organization learned, when you allow lawyers to bring lawsuits without clients who have suffered injury and who don't have appropriate standings, sometimes shakedown lawsuits occur. Because without evidence of harm and without knowledge that the offset that you bought really was problematic, there shouldn't be a lawsuit. And for those reasons, we must respectfully oppose this bill.
Any others in opposition?
Good morning, Madam Chair. This is Dorothy Rothrock with the California Manufacturers and Technology Association. And I know you're on a limited two-witness rule, but just briefly, one thing about this bill that's not apparent is it doesn't just apply to consumers who are perhaps in an unsophisticated position to be able to determine whether an offset is real or not. It would apply to any business-to-business transaction where you'd think that there was enough sophistication so that companies could determine what they were buying is worth what they are willing to pay for it. And I think that it's it's overly comprehensive in the sense that it covers those kinds of transactions as well. Thank you.
Juanita Martinez with KP Public Affairs on behalf of the Western States Petroleum Association in opposition.
Amisha Patel with the California Chamber of Commerce, here in opposition.
And Blair Knox with the California Independent Petroleum Association in opposition.
Any other witnesses in opposition? The motion is to refer to Judish. Questions by members?
I'd like to, this is not under the category of harassment. It's sincere and serious. I would like to hear Mr. Lipper respond to the concerns about the method of enforcement that were just addressed by the opposition.
Certainly.
Thank you, Mr. Chesbro. The opposition raised several arguments, and let me try to go through them as Senator Steinberg did in the earlier presentations that he made. First of all, the representative from SEEB said there are only 3 ways to comply with this law, but he fails to note that one of those ways, that is complying with a protocol by the Climate Action Registry, would consist of meeting a very broad protocol that applies to an entire sector, say the oil and gas sector or the energy sector or the forestry sector. And so these are very broad standards that give ample room for any party to be able to say, we're meeting that standard, therefore, in our advertising and in our claims to you, the public, whether you're a small business person trying to offset your carbon emissions or whether you're an individual trying to do that, that you're in compliance with the law. In addition, the Air Resources, both the Air Resources Board and other agencies are actively looking at adopting regulations to authorize voluntary carbon offsets. So the notion that these standards are unavailable, I think, is mistaken. With respect to enforcement, Mr. Chesbro, this law is enforced in exactly the same way every other unfair business practices action is enforced. That is, by district attorneys, by the Attorney General, by individual citizens if they choose to do so. But the vast majority of actions that are brought under state law are brought by the same entities that impose civil and criminal penalties on violators of environmental laws, and that's what this law speaks to. One last thing I would say, the representative from the California Civil Justice Association said that there doesn't have to be any harm shown. If you'll note, in the bill, that provision was in the bill and was stricken for the simple reason that the Senator Steinberg took that amendment and the CJAC representative said that it wouldn't change their position on the bill. So this is consistent with the way other laws are written right now. We had put in this standard of harm as a concession to CJAC, and they continue to oppose the bill and let us know that they wouldn't change their position. Some of those issues, of course, will be looked at by your Assembly Judiciary Committee, but again, I want to emphasize this is the same enforcement action that exists today. If you inaccurately claim that the fruit that you're selling is organic when it really isn't, or when you claim that your toothpaste is going to whiten teeth when it really doesn't, it's the same standard we apply to all deceptive advertising and the same enforcement mechanism.
Other questions? So just let me see if I understand this right, Mr. Lipper. So the senator had originally in the bill the issue of that the case of action could be brought by any person who can show harm or by a governmental entity, but then decided to amend it and strike that language.
Or if you look on page 4, line 29, you can see that the so-called harm standard was in the bill.
Correct.
Our Judiciary Committee, and I believe your Judiciary Committee, although we haven't arrived there yet, don't like that language. But as a concession to the organizations who oppose this bill, Senator Steinberg was willing to put that language in. However, once we put it in, these groups continued to oppose, and his view was, why would I make a change that on the policy I'm not crazy about and our committees don't like when the organizations who asked for it continue to oppose the bill? So that was his calculation of why that is not in there. It's also my understanding that that standard is not used for other kinds of actions, but again, I think your Judiciary Committee can share that with us. I don't know that he objects to the amendment on the merits so much as he would prefer the bill in the form that it's in now. We had made that change in the Senate. We got over to the Assembly and we received a notification from some of these groups that even with the change they would continue to oppose, and the question was, why make that concession when those groups are not going to change their position to begin with?
Okay. All right, so we have a motion before us, which is do pass as amended, and I did describe the amendments. Seeing no other questions, we will, unless you have additional comment you want to for close,
Thank
we
you.
will take the roll.
Skinner?
Aye.
Skinner, aye. Gilmore?
No.
Gilmore, no. Brownlee? Brownlee, aye. Chesbro?
Aye.
Chesbro, aye. De Leon? De Leon, aye. Hill? Hill, aye. Huffman? Huffman, aye. Knight? Knight, no. Logue? Logue, no.
The bill is out.
Thank you, Madam Chairman
Thank
and
you.
members.
To Judish. We have our businesses concluded?
Yeah, we just need to add on.
We will now have our, if anyone needs to add on, the no bills are on call. We just, if you want to add on, you can come over. I